referring to.
Right.
Mine's boggling. It's very ingenious.
This appeal concerns the right to paid annual leave under Regulation 4 of the Civil Aviation Working Time Regulations 2004 for crew members in the civil aviation sector. And there are two strands to the appeal. The first is the meaning of paid annual leave in the community and domestic provisions applying to crew members. And the second is the scope of the member state's discretion in providing for the right to paid annual leave and for a remedy for a breach of that right, and in particular, whether a specific formula needs to be provided in the domestic legislation for the calculation of normal pay. The claimants are all BA pilots, but the outcome of this appeal has implications for many thousands of crew members, that includes flight crew and cabin crew, across the civil aviation sector. And many of those have already brought claims in the Employment Tribunal which have been stayed pending the outcome of this appeal. Well, the facts of the case are relatively straightforward and indeed have been hardly in dispute from the very start of the proceedings. In short, the claimants, when they're working normally, typically fly for about 15 days a month. It varies. This doesn't mean they only work, of course, for 15 days per month. Their other duties may include things like simulator training, safety training, or other types of training. And they're paid, in addition to basic pay, a flying pay supplement, which is part of their salary, and a time away from base allowance, which is in part taxable at the relevant time to the extent of 18%. Well, my instructions are it's recently gone up to 21%. Those allowances are set out in a memorandum of agreement, which is a collective agreement between BA negotiated with the pilots' union, BALPA. And I wonder if I might just go to a few pages of that, which really set out the structure of the pay package. It's in the core bundle in the appendix at page 232. The memorandum of agreement is dated the 1st of April 2005, but it is, of course, there have been several memoranda of agreement before this. It is the collective agreement. This is effectively an amended version of an earlier collective agreement. And in relation to salaries, at page 234, paragraph 9, salaries shall be as the scales described in Schedule A attached to this agreement. And then simply to flag up at paragraph 11, provisions as to leave are in accordance with Schedule C. I'm not proposing to go to those. I think there's no dispute about them. But in relation to salary, if I could then turn to page 242, which is Schedule A, it sets out the scheme of pay. Again, I think there's no need to go into the sometimes complex detail of the BA pilot's pay scheme, but you'll see at paragraph 1.2 a reference to basic pay scales. And then there are various increments. And then if you go over the page to 244, flying pay. Paragraph 4, flying pay, which is included as part of salary, that is Schedule A, all relates to salary. Flying pay, trips will accrue a flying pay supplement based on standard planned sector times used in construction of the initial bid package or the standard sector time of a replanned trip. And then flying pay is further described at Appendix 2, which starts at page 247. Flying pay supplement, paragraph 1, is only paid for planned flying hours. It's non-pensionable. 2.1, it applies to all pilots, and then there are circumstances in which it does not apply. And then just turning over to page 248, there are circumstances where flying pay supplement is paid even when a pilot is not flying. For example, under the disciplinary process, that's paragraph 5, if there's a disciplinary allegation which is not proven and flying pay has been lost, then it's going to be repaid. And then in certain circumstances under paragraph 7, flying pay is paid for simulator instructor duties for certain pilots. Finally, in looking at the Memorandum of Agreement, at page 249, you'll see reference at 2.1 to the time away from base allowance, quite distinct from simply flying. It's the time away from base allowance, you'll see at the third paragraph, is paid for all flying, positioning and ground duties away from the crew member's designated base. Positioning is, for example, where a pilot is flown over on a flight as a passenger because the pilot's going to fly back on the same or another aircraft. So time away from base, you see, measured from crew members' report time to actual time of release, standard release from duty recorded as chocks plus 30 minutes. And then circumstances where release from duty can be extended.
Does this agreement tell you what happens if some pilot's going to have a baby or something, or takes a month off or something, 3 months off? Yes,
well, there are provisions on maternity. I'm not sure that we've included them in the extracts. The Memorandum of Agreement is a fairly lengthy document, and we've sought only to put in the relevant extracts. I will check whether we have got that.
Well, I don't mind if it's in or not. What's the position in that sort of situation?
Yes, well, there are provisions applying to those who are pregnant or take maternity leave. Indeed, there has been authority, in particular in relation to cabin crew who are grounded on pregnancy grounds.
Well, you'll let us know what the details are later, will you?
Lord, if it'll help, I'll come back to it later, yes.
Thank you.
What about the ordinary leave here? Is that in the contract as well? The payment for, well, holiday pay, is that in this contract as well?
The payment for holiday pay is dealt with in a fairly complex set of conditions which are known as the bid line rules. Can I, without wishing to duck the question in any way, just say that the payment of basic pay only during holiday results from a construction of the bid line rules, and we have not sought to put before your lordships and your ladyship the bid line rules, which were before the employment tribunal, and indeed an explanation has been given.
But it's in the statement of agreed facts, isn't it, that the effect of the memorandum of agreement and the bid line rules is that the contractual entitlement to leave pay is just the basic.
That's absolutely right. That is an agreed fact. Yes.
But just looking at the agreed statement of facts, paragraph 1, it refers to the collective agreement, the 2005 one we've just been looking at, and then says collectively agreed terms, including terms in relation to pay and holiday, are incorporated into pilots' individual contracts
Yes.
for employment. Do we have a specimen individual contract?
No, you don't have one. You
that
don't
wasn't
have one
before the tribunal
in
at
the
any
bundle.
level, was it?
I think the employment tribunal may have had a specimen contract of employment, but it has always been common ground between the parties that these are collectively agreed terms which are incorporated. And the collectively agreed terms span not only the memorandum of agreement but also the bid line rules. And that's how basic pay...
Is it possible to explain in one sentence what bid line means?
Not in one sentence, but there is a bidding process that pilots undertake when they bid for flights, and essentially they are rostered, taking into account their bids, but it also involves considerable complexities in relation to matters such as seniority.
So it's connected with the rostering of flights, is it?
It's connected with the rostering of pilots.
Lords, the agreed fact, which my Lord Brown referred, is at paragraph 4 of the agreed facts, where it's agreed that the effect of the memorandum of the agreement and the collectively agreed bid line rules, one has to read them together, is that the pilot's contractual entitlement for periods of leave is to basic pay, but not to FPS or TFA.
Yes, thank you. Yes.
In terms of the actual difference that's made to BA pilots by including only basic pay, we've set this out at paragraph 12 of the agreed statement of facts and issues. It gives obviously it depends on the individual pilot.
It's about 10% in the roughest terms.
Yes, yes. Paragraph 12, the lead claimant, Mrs. Williams, was receiving about £700 a month flying pay supplement.
Or even 1,000.
I think
Yes.
it might be.
More, 7,000, 8,000.
No, by way of flying pay supplement.
Oh, I'm so sorry.
By way of flying pay supplement,
cheap.
about £700 a month.
Yeah.
An inaccurate
She gets more by way of basic pay, and time away from base about £85 a month, but it varies from month to month. And you have, if you want to look at it, but I wasn't going to go to it in any detail, right at the back of the appendix at page 257, the actual breakdown of what Mrs. Williams received over a 12-month period.
When did she actually join BA, do you know?
I would have to go back to the ET1 to find her exact date of joining. Can I come back to that?
I mean, from the point of view of the pilots, how long has this dispute been going on? Did it just start in 2006? And could it be said that it doesn't relate to the legal merits, but it's a slightly odd situation if they all joined on the basis that they knew that holiday pay was X, and then 5 years later they said, well, actually it's 10% more.
Yes, well that's because the Civil Aviation Working Time Regulations came into effect, which gave them a right which they didn't have before. In terms of the contractual position has been basic pay. The reason that these claims are brought and can be brought is that the Civil Aviation Working Time Regulations don't provide for a contractual test in relation to the payment of holiday pay.
Yes, I see. So, I mean, the position is, as I said, but the reason is that the regulations came in.
Yes, absolutely. I'm told 1989 Mrs. Williams was first employed.
It's page 124
yes,
of
it's
the
in
appendix.
the application to the tribunal in the claim form.
So, I'm sorry, it was my fault. There were some regulations came in that suddenly entitled them to raise this claim, you say?
Yes.
Which are those regulations?
They're the Civil Aviation Working Time Regulations 2004. I will be going to those in a moment. They're at tab 10 of the bundle.
Is that the thing that implements the aviation directive?
Yes.
I see. So they come in at 04, and a couple of years later this claim arises.
Yes.
Okay.
Yes. Well, the claim arose following a grievance that was brought after the regulations came into force. A grievance was brought to BA, and then these claims
Well, that was
were
in
brought.
2006, yeah.
Yes.
When did they come into force?
The aviation regulations came into force in 2004
13th
on the
of April.
1st of October.
Oh.
But logically, it's actually, on one view, the directive.
Sorry, 13th of April 2004.
That's right.
Sorry, I said.
On one view, the critical date, if you were right, might be argued to be the date when the directive came into force.
Well, British Airways is not an emanation of the state, and the claimants have never alleged that it was an emanation of the state. And for that reason, they cannot, and have accepted throughout these proceedings, cannot rely directly on the provisions of the Aviation Directive.
Didn't have direct effect.
I think you should have a look at...
My Lord, whether it had direct effect...
But it didn't have it on a private enterprise.
Certainly the claimants couldn't rely on it having direct effect because BA was not is not an emanation of the state.
And there were... Yes, I see your point, yeah.
Yes. So for BA pilots, they've had to wait for the coming into force of the regulations.
Did I read somewhere that it was Unite that actually picked up this?
Yes, it was originally...
I haven't thought of it.
Well, the first grievance was brought by Unite on behalf of cabin crew because, of course, these regulations have a very significant impact on cabin crew, just as they do on pilots. So Unite were the first to raise it by way of grievance. BALPA then raised it by way of grievance, and it's BALPA that has brought the claims before the tribunal. But the claims have implications for cabin crew as much as for flight crew. And indeed, packages are very differently structured. This is a matter of agreement between the parties, between the various airlines, between different airlines. There may be very differently structured salary packages, some with a greater or lesser emphasis on basic pay. So, my Lords, in terms of the plan of my submissions today, what I propose to do is to take you to the relevant provisions of the Civil Aviation Working Time Regulations, first of all, then secondly, to set out those provisions within the specific nature and context of the right to paid annual leave within the European Labour Code on working time, with a brief reference to the international law background of the right to paid annual leave. Thirdly, to go to the authorities of the European Court of Justice, as it then was, in which the meaning of the expression paid annual leave and the scope of member states' discretion on implementation of that right in national law and or practice has been considered. Then I propose to go to the authorities relating to interpretation of domestic law, although I know your lordships will be very familiar with those authorities. That's when I'm going to refer briefly to the case of Gaydan, which has been handed in this morning. And finally, I propose to pull together our submissions following the shape of our written case on the required level of payment for annual leave and the requirements of national legislation and or practice. So, my Lords, could I start by asking you to take up Authorities Volume 1 and go immediately to the Civil Aviation Working Time Regulations, which are at tab 10.
Now, are these to implement a specific directive?
Yes, they implement the Aviation Directive, which is at tab 17 of your bundle and which I will be going to in a moment. You'll see they came into force on the 13th of April 2004, and paragraph 2, that they apply to persons employed to act as crew members on board a civil aircraft flying for the purposes of public transport. Crew members are defined, you'll see at the bottom of that page, in Regulation 3, as persons employed to act as a member of cabin crew or flight crew on board a civil aircraft. Cabin crew is then defined above, and flight crew you'll see defined on page 2 of the regulations. About 7 lines down, flight crew means a person employed to act as a pilot, flight navigator, flight engineer, or flight radio telephony operator on board a civil aircraft. You'll see that at the bottom of the interpretation section, there's a reference to the interpretation of working time. Working time in relation to a crew member means any period during which he's working at his employer's disposal and carrying out his activity or duties, any period during which he's receiving relevant training, and then finally at C, any additional period which is to be treated as working time for the purpose of these regulations under a relevant agreement. And relevant agreement is then defined above in relation to a crew member, means a workforce agreement which applies to him, any provision of a collective agreement which forms part of a contract between him and his employer, or any other agreement in writing which is legally enforceable as between the crew member and his employer. So in relation to working time, it is permissible for certain rights to be defined by collective agreement. No similar provision in relation to annual leave. That is solely in relation to working time. And then collective agreement is defined also in the regulations on page 1 as being a collective agreement within the meaning of section 178 of the 1992 Trade Union and Labour Relations Consolidation Act. The key provision then in the regulations, Regulation 4, is the entitlement to annual leave. A crew member is entitled to paid annual leave at least 4 weeks or a proportion of 4 weeks in respect of a period of employment of less than 1 year. Leave may be taken in instalments, and then 2B may not be replaced by a payment in lieu except where the crew member's employment is terminated. There is then a provision of paragraph 9 for maximum annual working time. It doesn't apply on the facts of this particular case. I draw attention to it only because it's the only other prescriptive regulation in the sense that there's no flexibility to it in these regulations. For example, if you look at pattern of work under Regulation 7, when an employer intends to organise work according to a certain pattern, he'll take into account the general principle of adapting work to the worker to the extent it's relevant to the objective of protecting workers' health and safety. That's an example of a regulation where there is a degree of flexibility, in contrast to Regulation 4, we say. And then in terms of the enforcement provisions, if you go to Regulation 11, provisions of Schedule 2 apply in relation to enforcement of the relevant requirements. And Schedule 2 sets out an enforcement mechanism, which I don't think I need to take you through. Simply say this, that this does not apply to holiday pay. That is the relevant requirements. And I'm afraid I have to take you back to the interpretation section for this. But the relevant requirements mean regulations 5.2, 6, 7.2a, 8, 9 and 10. So the enforcement mechanism for those particular provisions is by way of a scheme of inspection, and there can be criminal penalties. A person who fails, you'll see under 12, to comply with any of the relevant requirements will be guilty of an offence. Now, in contrast, in relation to paid annual leave, the only remedies provisions are found in Regulation 18, and that's where I go next. Under Regulation 18, a crew member may present a complaint to an employment tribunal that his employer has refused to permit him to exercise any right he has, and the relevant one here is under Regulation 4. At 18.2, the time limit provisions are set out. An employment tribunal shall not consider a complaint under this regulation unless it's presented before the end of the period of 3 months, beginning with the date on which it's alleged. 1, that the exercise of the right should have been permitted. And then 2, the payment under Regulation 4.2b should have been made. So 1 is the right to paid annual leave, and 2 is the right to a payment in lieu of leave following termination of employment. That's the payment under Regulation 42B. And then there is the reasonably practicable extension provided for in 18.2b. And then at 3, where an employment tribunal finds a complaint under Regulation 4 well-founded, the tribunal shall make a declaration to that effect and may make an award of compensation to be paid by the employer to the crew member. And then 18.4, the amount of the compensation should be such as the tribunal considers just and equitable in all the circumstances, having regard to the employer's default, first of all, and then significantly B, any loss sustained by the crew member which is attributable to the matters complained of. And 18.3 and 18.4...
But is there a provision about the payment of annual leave?
Well, the payment...
Because 42B is not about payment for annual leave, is it? It's about payment in lieu.
Yes. 14.2, yes.
You're not saying it's a 14.2b case at all, are you?
No, this is not about payment in lieu of leave, although exactly the same principles
That's right.
apply, as Your Lordship knows from the Stringer case. Exactly the same principles apply to payments in lieu. But paid annual leave, what we say, is a composite right. So where in 18.2a.1 there's reference to the exercise of the right means the right to annual leave and the right to be paid in respect of that leave. It's a composite right, and I'll take Your Lordship's...
Well, that's the time provision,
Yes.
18.2, but
Yes.
your claim is under 18.3 and 4.
Yes, that's right.
Well, we had some case all about this time business, didn't we? And I think we were told that this particular matter was all coming out. Were you in that?
It was Stringer, my lord.
Oh, that was Stringer
Stringer.
itself.
Stringer
Yes, of course it
was
was.
to
No, of
do
course
with
it was. Of course it was.
long-term sick employees of the Revenue and Customs, I think.
That's right, and I will be going to it in a little bit of detail in due course.
Yes,
Yes. Then looking at the community law framework and the international law background to this right, can I just start by going to the 1993 Working Time Directive, which is in the bundle at tab 13. Thank you. Because this is the first point at which paid annual leave appears specifically under the community law obligations. And I just wanted to take you, if I may, just to one part of the preamble, 2 parts actually, just about a third of the way down the page. It's whereas the provisions of Council Directive 89391 on the introduction of measures... I'm so sorry, I wanted to start on the paragraph below, I do apologise. Whereas the Community Charter of the Fundamental Social Rights of Workers, adopted at the meeting of the European Council held at Strasbourg on the 9th of December 89 by the heads of state or of government, 11 member states, in particular point 7, first subparagraph, 8 and 19, first subparagraph thereof, declared that, and it's 8 that I would take you to, that every worker in the European community shall have a right to a weekly rest period and to annual paid leave, the duration of which must be progressively harmonised in accordance with national practices. And then, if I could go just to the bottom of that page, whereas in order to ensure the safety and health of community workers, the latter must be granted minimum daily, weekly and annual periods of rest. And then over the page at the top, whereas account should be taken of the principles of the International Labour Organisation with regard to the organisation of working time, including those relating to night work. So simply flag up at this point that there are international instruments that are at least taken into account by way of background in the preamble to the Working Time Directive. And then if I take you down...
What is it that must be progressively harmonised in accordance with national practices? What does it mean when it says the duration? one's tempted to think there might have been a comma after harmonise, but I suspect perhaps not. Does it mean the periods of which, i.e. when you take it, or is it just means the length?
I think it means the length of which must be progressively harmonised. That is, that there must be harmonisation.
But then it says in accordance with national practices. How do you harmonise it in accordance with national practices?
Because the right can remain the same immutable right, but national practices may provide conditions and procedures for how that right is exercised.
Either you have to take it all at once, or 2 weeks at a time, or in some countries
Exactly,
you would take it a day at a time.
Yes, exactly. It's about how it's done rather than the right itself. So against that background then, going to Article 1.3, the Working Time Directive, you'll see, is to apply to all sectors of activity, both public and private, within the meaning of Article 2. And then it says, with the exception of air, railroad, sea, inland waterway, lake transport, and so on. So there were exceptions in the Working Time Directive which related inter alia to air transport.
Do we know why? I mean, is there some obvious and immediate pointer as to why in the recital or anything?
Well, the reason why, my lord, is that these are sectors where working hours, by the very nature of the work carried out, are different. There are different implications raised. For example, seafarers may very well be on 3-week voyages. Those who are flying may be flying to the other side of the world. It's not possible for them to work within a normal 9 to 5 or indeed any other shift sort of pattern. So it was recognised that there were sectors of activity where the nature of the activity meant that it was more difficult to bring them within the parameters of the working time, but that nevertheless the principles remained the same, and it was intended, as you'll see in due course, they were brought within the framework.
Where do we find the exception? I haven't found it.
Yes, it's Article 1.3.
I mean, I think Lord Justice Rymer suggested there wasn't anything very obviously generous with the doctors in training. I think he said that, didn't he?
Oh, yes.
He did.
Yeah.
Yes. Yes.
I mean, there must be quite a lot of others who could fall into this non-category of those who are pretty exceptional, really, in their working practices and so forth. However, there it is.
Well, there are quite a lot of other derogations. I was looking at Article 17, aren't there? You can derogate from all sorts of categories. Member states can.
Lord, I was going to come to the derogations because the significant fact in relation to this case is that Article 7 is one of the articles from which there can be no derogation. But I'm reminded by Mr. Ford that, in fact, the Commission gave an undertaking to Parliament, the European Parliament, that it would revisit the mobile workers at a later date following this, and you'll see how, in fact, that develops. But if I could just refer to Article 7, which is the provision for annual leave in the Working Time Directive. Member States shall take the measures necessary to ensure that every worker is entitled to paid annual leave of at least 4 weeks, in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation and or practice. And this is a formulation that you will see repeated in relation to paid annual leave in other directives. Article 14 I should just draw your attention to, because Article 14 did provide for more specific community provisions, that the provisions of the directive shall not apply where other community instruments contain.
I'm sorry, which one is this?
Article 14.
14, my fault.
Yes, it's at the top of the third page. Of course, at this stage, there were no other community provisions for aviation workers.
So this is just part of the history, is it?
Yes, this putting these in, putting in context how this developed. Member States were required to comply, to comply with this directive by the 23rd of November 1996. You'll find that under Article 18. In fact, there was a challenge to the Working Time Directive by the UK government in a case which Mr. Jeans relies on, UK against the Council of the European Union, so that in fact the domestic law regulations did not come into force until the 1st of October 1998. Now, the domestic regulations that came into force were the Working Time Regulations 1998, and you'll find those at tab 4 of volume 1. And I'm going to refer to them only really very briefly, because I'm going to take you in a moment to the regulations in force at the time of these claims. But just really to flag up, the Regulation 13 of those working time regulations provided for the entitlement to annual leave. And you'll see from 13.2a, it was originally 3 weeks, and then it gradually increased until, for any leave year beginning after the 23rd of November 1999, to 4 weeks. So that was the entitlement to annual leave. There was a provision for payment in lieu of leave, which you find in Regulation 14.2. And then if you go to Regulation 18, there's a reference to the excluded sectors, and you'll see at 18A that air transport was one of the excluded sectors in the 1998 regulations.
And is there anything in these regulations about how the payment for leave should be calculated?
Well, in relation to remedy and in relation to the payment, there is a complex scheme of calculation. It's referred to in paragraph 16, Regulation 16. That pay is at the rate of a week's pay in respect of each week of leave. And sections 221 to 224 of the Employment Rights Act 1996 apply for the purpose of determining the amount of a week's pay. And sections 221 to 224 of the Employment Rights Act set out a fairly complicated formula which has been considered on many occasions, certainly up to the Court of Appeal level, for calculation of pay in what might be described as the less straightforward cases. So within these regulations, there is a specific formula for calculation referred to and incorporated. And then I was just going to refer to Regulation 30, which is the remedies provision. Where there is provision at 31A, presenting a complaint to an employment tribunal for refusing to permit a right, and then at B, failing to pay the whole or any part of any amount due under Regulation 14.2 or 16.1. So that again refers to the provisions in relation to pay, 14.2 being specifically pay in lieu of leave. Then there's provision at 33 for an employment tribunal to make a declaration and make an award of compensation. And then at 4, the amount of the compensation shall be such as considered just and equitable. And then there is a separate provision at 5 that where there's been a failure to make a payment in accordance with 14.2 or 16.1, the tribunal can order the employer to pay to the worker the amount which it finds to be due to him. And it is, in essence, the 33 and 34 structure that you find in the civil aviation working time regulations, and not the additional 35.
And why is that?
Well, Lord, the reason for that is that Parliament has enacted the regulations in that particular way. We submit that it is a wholly sufficient way to enable there to be a remedy for a breach of the right to paid annual leave.
I'm sorry, I'm obviously thinking too simplistic terms, but isn't it that these regulations actually do set out how you calculate what the pay is, so they give you a specific remedy if you don't get it?
Yes.
Whereas the aviation regulations don't do that, so you just fall back on your compensation.
Yes, so it's compensation assessed on a just and equitable basis.
That's why there isn't an analogue of Regulation 35.
Yes. Lady, yes.
But you say it comes to the same thing.
Yes, we say it comes to the same thing, that the Regulation 18 provides a perfectly adequate remedy, indeed, in European terms, an effective remedy, for providing for compensation in the event that you are not paid your normal pay during annual leave. Well, the next matter in the European law history is the amending directive of 2000, which is at tab 16 of the bundle. And if I could just start again with the preamble. Subparagraph 3, you see reference to the fact that road, air and others are excluded from the scope of Council Directive 93/104, that's the Working Time Directive. Commission in its proposal of 20th of September 1990 did not exclude any sectors and activities, nor did the European Parliament in its opinion of 20th of February 1991 accept such exclusions. Paragraph 5, health and safety of workers should be protected at the workplace, not because they work in a particular sector or carry out a particular activity, but because they're workers. As regards sectoral legislation for mobile workers, a complementary and parallel approach is needed in the provisions on transport safety and the health and safety of the workers concerned. Account needs to be taken of the specific nature of activity at sea, and doctors in training. Protection of health and safety of mobile workers in the excluded sectors and activities should also be guaranteed. And then paragraphs 9 and 10, there's a distinction made between different types of rights. The existing provisions concerning annual leave and health assessments for night work and shift work should be extended to include mobile workers in the excluded sectors and activities. The existing provisions on working time and rest need to be adapted for mobile workers in the excluded sectors and activities. And that picks up on the point put to me by Lord Brown earlier this morning, that there are that the reasons for certain sectors being excluded in relation to working time is that the manner of work, the patterns of work are very different. But in terms of annual leave and health assessments, the preamble suggests that there should just be an extension of the existing rights to them. Then there's reference to paragraph 14 to specific standards laid down in other community instruments. I simply say there were none at this time relating to the civil aviation sector. Preamble paragraph 15, I just flag up that the deletion of the provision relating to Sunday rest arose from the UK against Council of Europe decision. And then looking at the terms of the directive itself, Directive 93/104 EC is amended as follows. and it provided, first of all, Article 1.3 was going to be replaced. The directive wouldn't apply to seafarers. And then at Article 2, it says, in Article 2, the following shall be added. Mobile worker shall mean any worker employed as a member of travelling or flying personnel by an undertaking which operates transport services for passengers or goods by road, air, or inland waterway. And then at 4, Article 14 is replaced, although in fairly similar terms to the previous one, that the directive would not apply where other community instruments contain.
Sorry, you've lost. Where are you now?
I'm so sorry.
No, it's my fault. I was looking back at the actual thing that we're amending, which is tab 13.
Yes, which is tab 13, yes.
Sorry, but where have we got to in tab 16? My fault.
Yes, it's at top of the second column. It refers to Article 14.
Oh, yes, I've got it.
And Article
yes,
14
yes.
is where there are more specific community provisions. That is amended.
Yeah.
And then just looking at mobile workers and offshore work, which is in the second column on the next page, L195/43, mobile workers and offshore work. Articles 3, 4, 5 and 8 shall not apply to mobile workers. So envisaged at this time that Article 7, which is the working time, which is the paid annual leave provision, would apply to mobile workers. So the pattern is that mobile workers have at this stage, within the directive at least, been brought within the framework, and it's plainly envisaged that Article 7 of the Working Time Directive, paid annual leave, will apply to them. And that directive was to be brought into force by the member states no later than the 1st of August 2003.
3?
Yes, no later than the 1st of August 2003.
I'm terribly sorry, where's that?
You find that at Article 2.1 on page L195/44. Member States shall bring into force the laws, regulations and administrative necessary to comply with this directive no later than the 1st of August 2003.
These are our amendment regulations of 2003, are they? That brought them into effect.
This is 2000. This directive is 2000.
I know it is, but they were brought into effect here by our working time amendment regulations.
Yes, by the amended, yes, the working
Where are
time
they?
regulations 2003, which...
There's tabs there.
10, is it?
I'm not sure we've,
No.
I'm not sure we've have those in. We've got the regulations as amended, which you'll find at tab 5 of the bundle. But what happened was that the inclusion of mobile workers in the air transport sector was effectively superseded in the sense that the aviation directive comes between the 2000 Working Time Directive, amending directive, and the 2003 consolidated directive, which I'll go to in a moment. So,
I see. So 5 as a result of both. The 2003 regulations are the result of both, are they?
No, because in the aviation sector, what happens in practice is that there is a European agreement
Is it set out
sorry,
conveniently on a single piece of paper? And a chronology.
If Peel can tell us the tale, we
You're
might
quite
get
right,
there.
it's my fault.
And if we could subsequently have it on a single piece of paper with a chronology so we can see precisely the position,
We
that'd
have
be of
that
the
in our
greatest
case,
It's
but
in
I'm
the doc,
certainly,
yes.
certainly happy. Overnight we'll try and put the chronology. I would like to say that I wish it wasn't complicated, but it
Well,
does
that's
take
fine.
a bit of wading through, and I do apologise. Following the 2000 amending directive, you have the aviation directive, and that is in the bundle at tab 17. And this is the aviation directive, which is the root of the domestic aviation working time regulations.
And this is the lex specialis.
Yes, at this stage, the European agreement has been reached in March 2000, 22nd of March 2000. And the aviation directive comes into being on the 27th of November 2000, with the requirement, which you'll find at Article 3, that the Member States bring into force the necessary laws, regulations or administrative provisions by the 1st of December 2003. So the relevant, just again, looking at the preamble, you'll see reference at paragraph 2 to Directive 93/104/EC. That is the working time directive. And then to the amending directive in order to cover sectors and activities previously excluded. And then there's reference to the European agreement. You'll see that at 5. That there's been negotiations, side of management and labour. And paragraph 6, the organisations concluded on the 22nd of March 2000 a European agreement on the organisation of working time of mobile staff in civil aviation, which contained a joint request to the Commission to implement the agreement by a Council decision on a proposal from the Commission. At 8, you'll see the directive and the agreement lay down more specific requirements within the meaning of Article 14 of Directive 93/104 as regards the organisation of working time of mobile staff in civil aviation.
Now that agreement is what the Statement of Facts and Issues call the Aviation Agreement, is it?
Yes, yes. And it's annexed to the directive. You find it immediately after the directive at L302/59.
The second sheet of paper.
The second sheet of paper
I see.
contains the aviation agreement. And then you'll see at paragraph 12, and I just highlight this because it's a provision that BA specifically relies on. With regard to terms used in the agreement which are not specifically defined therein, this directive leaves Member States free to define those terms in accordance with national law and practice, as is the case for other social policy directives using similar terms, providing that the said definitions are compatible with the agreement. And then if I could just go over the page to 15 of the preamble, this directive and the agreement establish minimum standards. Member States and or management and labour may maintain or introduce more favourable provisions. Implementation of this directive should not serve to justify any regression in relation to the situation which already exists in each member state. And we highlight that in particular because it makes it clear that the aviation directive could not go back on any existing rights or indeed take away from them. And you'll see that also in Article 2.2, the implementation of the directive shall under no circumstances constitute sufficient grounds for justifying a reduction in the general level of protection of workers in the fields covered by this directive. And then there's the provision on bringing into force laws, regulations and administrative provisions. Now, the agreement which is annexed, at clause 3, provides for paid annual leave. Mobile staff in civil aviation are entitled to paid annual leave of at least 4 weeks in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation and or practice. And if that sounds like an echo, it is an echo of what's in Article 7 of the Working Time Directive. Minimum period of paid annual leave may not be replaced by an allowance in lieu, except where the employment relationship is terminated. And then there are further provisions on health assessment and the maximum annual working time, which is set out at Clause 8, Paragraph 2. And then if I go to...
So nothing about the level of pay or how it should be calculated?
No, nothing about the level of pay or how it should be calculated, and indeed no requirement that the level of pay should be provided for in national legislation or practice. And then the Consolidated Working Time Directive is next in the chronology.
Just before we go to that, this
yes.
European agreement was negotiated between various trade bodies and IARCA, so that
yeah.
it wasn't negotiated as a European document. It was simply negotiated as agreement, which is then annexed to a European document.
Yes, it was.
So how do we, admittedly it echoes the language of European Working Time Directive, but how do we, ultimately we're concerned to construe its language. Is it to be construed against the background of the negotiations? Is there any information about that at all, or are we just construing it in the void?
You construe it as it's effectively part of the directive. That is, it's annexed to the directive, and that is in accordance with the community provisions. If you go back to the preamble, it derives from consultation provisions. You'll see this at 3. The Commission, in accordance with Article 1382 of the treaty, has consulted management and labour. So this is a course that is provided for within the treaty on the possible direction of community action. And the Commission decided to consult management and labour at community level on the substance of the envisaged proposal, again in accordance with a treaty provision. And it's against that background that the European agreement is produced, and then the mechanism is that it contains a joint request to the Commission, you'll see this at paragraph 7 of the preamble, to implement the agreement by a Council decision.
Yes, but ultimately it is an agreement, and it may or may not have the formal status of a contract, but it's an agreement which one might construe against the background of the negotiations, but we don't have any information about that at all.
There's no information about the negotiations. I think the tribunal mentioned that the level of payment was a matter. There was no evidence before the tribunal that level of payment was a matter discussed during the course of negotiations. Article 1 of the directive perhaps indicates how the agreement is effectively incorporated.
Well, of course it is incorporated, but
yes.
The point I'm making is that it's incorporated for whatever it means, and what it means might take some colour from the industry understanding of what was paid in respect of periods of annual leave.
Yes.
Let us suppose this has been an agreement between simply between BA, representatives of BA staff and other airline staff. It isn't, it's wider, but suppose it had been, then one might say, for years they've had a practice of only paying the basic pay, and that is a very material background circumstance to the construction of this agreement as to what they meant by paid annual leave of 4 weeks.
My lord, yes, if it's a domestic agreement, of course, if it was an agreement between BA, this is a European-wide agreement which the parties have asked, management and Labour have asked, be implemented by way of directive.
But presumably this business of paying basic pay may well be a European-wide practice, of which all mobile staff in civil aviation and their organisation was one of the was the first. All representatives of associations of European airlines and European transport workers and so on would be well aware of. One doesn't know.
There was no evidence to that effect at all, and indeed there was some evidence before the tribunal of negotiations. But there has been, there's no evidence that throughout the community everybody just pays basic pay. I mean, what is clear is that there are different arrangements, not just, I suspect, from country to country, but even between from airline to airline in this country. So really there's very little, I submit, that can be derived from what is at best an absence of evidence. We submit that what is absolutely clear is that the aviation directive, in relation to annual leave, paid annual leave, is plainly intended to have the same meaning as under the working time directive. The language is the same. It follows on from the 2000/79 directive, in which mobile workers in air transport were brought within, briefly, the framework of the directive in relation to annual leave. But I will develop my submission on that in due course.
I'm so sorry.
I'm so sorry.
Just for your lordship's note, there is a finding by the Employment Tribunal in paragraph 37 of its judgment on page 73, where they specifically find that the question of pay, compensation, was not high on the agenda of the European Cockpit Association, the EU Pilots Trade Union Federation, which included BALPA. That's as close as one gets in paragraph 37 on page 73. Yeah.
Quite right, that's the only finding in the tribunal, and in the agreed statement of facts, if I could just go to that, at paragraph 3, it's page 2 of the agreed statement of facts.
Yes.
No discussion. Letter D, there was no discussion as to how holiday pay should be calculated for pilots and other crew members during the negotiations which resulted in the aviation agreement. That's as far as the evidence goes.
The fact that there was no discussion might be relevant if there were a further finding, because it was understood that holiday pay always was basic pay, but there isn't that finding.
There's no such finding. No.
So why not as between... So far, there's no indication that it can't be as agreed between the parties, so far as quantum of the pay is concerned, is there?
Well,
nothing we've seen so far which suggests that.
Well, the reason it can't be agreed between the parties is because it's a community law concept.
No, quantum, I'm talking about.
No, quantum is all part of it, because paid annual leave means, and I will be going to the European authorities in a moment, paid annual leave means being paid normal pay, means maintaining your normal pay.
Well, I understand you may have a European case which wins the day for you, and if it does, it does. If it doesn't, it doesn't. All I'm saying is that so far we haven't seen anything in this material which suggests that you couldn't pay, the airlines or anybody else couldn't pay annual leave pay, in accordance with whatever agreement was reached between the parties.
Well, if your Lordship's putting it to me that there's nothing that spells out how you calculate pay...
Or mentions it at all.
...for annual leave, there is, of course, in the working time regulations. There is not in the civil aviation working time regulations.
In the working time regulations, the basis for that provision, which I think applies sections 221 to 4, is what? Under what provision in the working time regulation?
It's regulation 16.1 of the working time regulations.
So under the directive, which provision is it that allows national law to regulate the calculation of pay?
Well, national law and or practice can set out, and it's permissive, can set out provisions in relation to matters such as calculation. And in relation to the working time regulations, that is indeed what Parliament has done.
So what do you accept, therefore, that the phrase, every worker is entitled to paid annual leave of at least 4 weeks in accordance with the conditions for entitlement to and granting of such leave, in other words, paid annual leave, laid down by national legislation and or practice, entitles the national legislator to regulate the quantum of the paid annual leave?
No.
Well, I thought you just said that.
No, I accept that it entitles the domestic legislation to provide for calculation, but what it can't do is take away from the fundamental right, which is to normal pay or normal remuneration. So it can provide for calculations, no doubt for different methods of calculation, provided that you do not in any way reduce the quantum below the guaranteed threshold.
But that's a European Court gloss, isn't it? You don't find that in any of the texts we've so far looked at, do you?
Well, when your
If so, where do you find it? Where's the best place for finding it?
Well,
or
your Lordship says
inferring
it's a European law gloss. It does arise out of the interpretation of what paid annual leave means in the authorities of the European Court of Justice.
Quite.
It does.
It doesn't appear from just looking at the language, does it, that we've seen so far?
Well,
just looking at the language.
Just looking at the language, it is our submission and has been below that as a matter of ordinary domestic law interpretation, on an objective analysis, if you're told that you're entitled to paid annual leave, you would understand that you would be paid your normal pay. But, my Lord, subject to that, no, it is not spelt out specifically in the directives, in the terms in which it's explained in the European Court of Justice.
I mean, going back to the aviation agreement, clause 3, you rightly say it totally mirrors, echoes Article 7 of the Working Time Directive, right?
Yes.
And that, as I understand it, is then implemented by us in the Working Time Regulations at tab 4.
Yes.
And that takes you to Regulation 16, and that introduces you to sections 221 to 4 of the 96 Act.
Yes.
And it's there, if these weren't aviation workers, that they would be entitled, so to speak, to the more than basic pay. Is that the point?
Well, it's not that they'd be entitled to more than basic pay. They would be entitled to pay that was calculated in accordance with the formula set out in the
which would
Employment
be
Rights
more
Act.
than basic pay.
In the context of this case, yes,
Yeah.
if these pilots fell within the ordinary working time regulations, they would be receiving more than basic pay.
Under that provision.
Yes.
But I mean, as we know, they're accepted from that explicitly.
Yes.
So we don't have that particular route to your success.
Yes. That's right.
What happens in relation to workers who are paid, who work overtime under sections 221 to 4 as a matter of interest? Is that part of their average weekly remuneration, if they happen to have chosen?
The provisions, I know Mr. Jeans is dying to leap up and tell you about them, and he will have the opportunity in due course, but they are complex, and they have given rise again to a number of cases, including a case called Evans and Malley, which I've no doubt Mr. Jeans will be taking you to. But if I say it depends, I appreciate it's not a very helpful answer, as the way the domestic law authorities stand at the moment is, in a case called Bamsey, it was found where there was overtime which was non-contractual, that was not taken into account. But that is a case which predates the European authorities of Robinson Steel and Stringer, and depended on the particular construction in section 239 of the Employment Rights Act, which applies to employees who have no normal working hours. In essence, without wishing to simplify it too much, the statutory regime under the Employment Rights Act 1996 divides employees into those with normal working hours and those who have no normal working hours. And there is an averaging provision for those with no normal working hours. And in some circumstances, I'm reminded, for those with normal working hours. There's an averaging process.
Which version of the working time regulations is it going to be most helpful for us to
Well, I think it's most helpful.
Because we have 3 different versions.
You do. I think it's most helpful to look at the ones which were applicable at the time of the claims, which are at tab 5. I wasn't proposing to go to the current ones at all, tab 6. I don't think there's anything in them that is going to assist you. Just before coming to those, and really just to complete the background, and I am getting close to the end, tab 18 has the consolidated working time directive. So this is the consolidated directive of 4th of November 2003. And can I just, on the preamble, highlight again subparagraph 6, which refers to account being taken of the principles of the International Labour Organisation. And then can I point out that Article 7, which you find on the second piece of paper, top of the right-hand column, Article 7, annual leave, replicates in identical terms what was contained in the Working Time Directive 1993. And then turning back to tab 5 and the Working Time Regulations 1998 as amended and as current.
But of course, Article 14 excludes those for which there's more specific community provision.
Yes. That's right. So tab 5.
I mean, we marked up tab 4 places like Regulation 16, but we are going to be looking at it henceforth in tab 5, are we?
Yes, my lord, I apologise for that. I thought it was necessary to go to the original working time, but really it's probably best to work from tab 5. And so if I can just flag up really by way of markings. 13 is entitlement to annual leave. Regulation 13 is entitlement to annual leave. Regulation 14 is compensation related to entitlement to leave. And 14.2, proportion of leave taken is less than the proportion of the leave year payment in lieu, so it's 14.2. 16.1.
Well, that's the crunch.
And then 18, excluded sectors. Now, there have been quite significant amendments here because the regulations now do not apply at all, you'll see at A, B and C, to categories of workers who we've been describing below as the seafarers, the non-fishing seafarers, the non-fishing seafarers, the seafarers and the inland waterways.
And these are as at what date?
This is following the amended regulations, substituted by Working Time Amendment Regulations 2003, so it followed the amendment.
There are also some 2004 amendments in there.
Yes, and some 2004 amendments, that's quite right.
So it's as at what date?
These are the date of the claims in 2006. These were the current provisions. And you'll see the substitutions are referred to in the notes. As far as aviation workers are concerned, you'll see under 18.2, and the important regulations are 13 and 16. Regulations 13 and 16 do not apply, and then at B, to workers to whom the European Agreement on the Organisation of Working Time of Mobile Staff in Civil Aviation applies. So at this point, aviation workers are within the regulations for some, although fairly modest purposes, mainly referring to young workers. But for paid annual leave, they're not within these regulations because they have their own regulatory regime under the Civil Aviation Working Time regulations.
Which we looked at a long time ago, and that's just Regulation 4, paid annual leave ungarnished.
Yes.
And that's tab
4. Tab 10, sorry, tab 10.
Yeah.
And it's Regulation 4. In terms of the international law background to this right, and I refer to this not because we're relying on any provisions of international law directly, but because it serves as a reference point when interpreting the Aviation Directive and Agreement. Makes it clear that it is a fundamental social right with long-standing roots in international law and a universal right for workers to have paid annual leave. It's not a sector-specific right, and its history goes right back to 1936. I'm not going to go through it in any detail at all. But
this case isn't about whether you're entitled to paid annual leave. It's about how much you should be paid for the paid annual leave.
What does paid mean?
Yeah.
Yes. But the paid element of it is very much a composite part of the right, and what we do say is that it's a non-sector specific right, and it's a right that's been recognised in international law over a very long period. You've seen from the preambles I've already taken you to that there are references in the preambles to the Working Time Directive, in particular to the Community Charter of the Fundamental Social Rights of Workers, and also to the International Labour Organisation documents. I think probably the simplest way of dealing with this is, I wonder if I could take you in Authorities Volume 3, just what is really the summary of these provisions in the Stringer case, which is at tab 43, and I will be addressing you on the case in a little bit more detail in due course, but there is a useful summary by the Advocate General, paragraphs 48 to 53, page 944.
So which tab is it again?
F. Authorities Bundle 3, tab 43.
And the summary is at?
It starts at paragraph 48, and it really goes through to paragraph 53. And I certainly don't want to labour matters by going through this in any great detail. But it's useful to see that in interpreting issues which were in some respects similar to the issues in the current case, the Advocate General in Stringer did think it was appropriate to set the background of the entitlement to paid annual leave as a fundamental social right. And refers to Article 24 of the Universal Declaration of Human Rights. You'll see that at paragraph 48, about 6 lines down, which conferred on everyone the right to rest and leisure, including reasonable limitation of working hours and periodic holidays with pay. It's December 1948. Then the social Charter of the Council of Europe 2.3, which also referred to annual holiday pay. The International Covenant on Economic, Social and Cultural Rights, so again a UN declaration. And then there's reference at 49 to the framework of the International Labour Organisation conventions, which refer to a right to a minimum period of paid annual leave. And I will take you in a moment just to those conventions which are specific to the aviation sector. Sorry, to all sectors. Then there's reference to the Community Charter of the Fundamental Social Rights of Workers, paragraph 50. The Charter of Fundamental Rights of the European Union, which you see at paragraph 51, and Article 31.2 of that Charter declares every worker has the right to limitation of maximum working hours to daily and weekly rest periods and to an annual period of paid leave. And leaving it there and just going back to the International Labour Organisation documents, we have included those in the authorities bundle. They're in the first bundle at 20 and 21. And the first of those at tab 20 was the Holidays with Pay Convention 1936. And Article 1, you'll see at subparagraph C, applied, amongst other sectors, to air transport. Undertakings engaged in the transport of passengers of goods by road, rail, inland, waterway, or air. And then at Article 2, an entitlement to annual holiday with pay at the stage of at least 6 working days. And then Article 3, and this is where payment is referred to, every person taking a holiday in virtue of Article 2 of the Convention shall receive in respect to the full period of the holiday either his usual remuneration, calculated in a manner which should be prescribed by national laws or regulations, including the cash equivalent of his remuneration in kind, if any, or the remuneration determined by collective agreement. Now, when that convention came to be revised in 1970, which you'll see at tab 21, the provision in relation to holiday, first of all, at Article 3.1, at the top of the second page, every person to whom this convention applies shall be entitled to an annual paid holiday of a specified minimum length. And then at paragraph 3, should be no less than 3 working weeks for 1 year of service. And then Article 7.1, every person taking the holiday envisaged in this convention shall receive in respect to the full period of that holiday at least his normal or average remuneration, including the cash equivalent of any part of that remuneration which is paid in kind and which is not a permanent benefit, continuing whether or not the person concerned is on holiday, calculated in a manner to be determined by the competent authority or through the appropriate machinery in each country.
Well, I mean, that's to deal with things like if he's allowed free food in the canteen or something like that.
Absolutely. And what's noticeable is that the provision about remuneration determined by collective agreement, which appeared in the earlier ILO convention, is no longer to be found in the 1970 convention, where holiday pay is defined only in terms of normal or average remuneration. And that foreshadows, we say very clearly, the provisions of the working time code in relation to paid annual leave.
The working time code.
Yes, when I say code, the European Labour Law Code on Working Time, which includes all of the directives which I've taken you to, including the aviation directive. Lords, I wasn't proposing to go to the domestic law regulations relating to inland waterways, seafarers and non-fishing seafarers, unless you'd like me to do so. In short, our submission is that those are domestic regulations which are not going to assist this court on the interpretation of the civil aviation working time regulations, because the civil aviation working time regulations must be interpreted in accordance with community law and not by reference to other domestic law provisions. But perhaps I can reserve my position to respond more fully on those regulations in reply when I've heard what Mr. Jeans has to say.
You take the course that you think best, Ms. McNeil.
Thank you. Can I then now turn to the authorities of the European Court of Justice in which paid annual leave and the scope of Member States' discretion on the implementation of the right to pay for annual leave have been considered? And can I start with the Bectu case, which is at tab 41 of Authorities, Volume 3. Full title set out at the top of the page, but it's tended to be known as the Bectu case, and if I may, that's how I'll refer to it. In judicial review proceedings, the applicant trade union, whose members worked in the broadcasting, theatrical and related sectors, challenged the validity of Regulation 13.7 of the Working Time Regulations 1998, whereby the entitlement to paid annual leave conferred by the regulations did not arise until a worker had been continuously employed for 13 weeks. The union maintained that since most of its members were engaged on short-term contracts, they were deprived of the annual leave entitlement, even though they were in regular employment, albeit with successive employers. The union contended that Regulation 13.7 constituted an incorrect transposition of Article 7.1 of the Working Time Directive, which required member states to ensure that all workers were entitled to at least 4 weeks paid annual leave, in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation and or practice. On a reference to the Court of Justice for a preliminary ruling on the question of whether Regulation 13.7 was compatible with Article 7 of the Working Time Directive, it was held that in the light of the purpose and scheme of the Working Time Directive, the conditions in Article 7.1 referred only to the details of arrangements made for the implementation of the article, and the phrase "in accordance with" those conditions did not allow member states to make the existence of the right to paid annual leave, which was a particularly important principle of community law, subject to preconditions, that accordingly a rule that workers were not entitled to paid annual leave until they'd been in 13 weeks continuous employment was not permitted by Article 7. There was a reference by the High Court. The terms of the reference can perhaps most simply be found at page 1156, at paragraph 18. It's just above letter H of the Advocate General's opinion. In order to determine whether the implementing regulations are compatible with Directive 93104 and whether the annulment sought should be granted, the High Court considered it necessary to seek a preliminary ruling from the Court of Justice under Article 234 EC on the following questions. Is the expression "in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation and or practice" in Article 7 of the Working Time Directive concerning certain aspects of the organisation of working time, to be interpreted as permitting a member state to enact national legislation under which A worker does not begin to accrue rights to the paid annual leave specified in Article 7, or to derive any benefits consequent thereon, until he's completed a qualifying period of employment with the same employer, but B, once that qualifying period has been completed, his employment during the qualifying period is taken into account for the purpose of computing his leave entitlement. And I don't think I need to go to 2 because it did not fall to be determined, the first question having been answered in the negative. But the Advocate General considers the nature of the right to paid annual leave in the Working Time Directive, starting at paragraph 22, which is at the bottom of page 1157, and places the right to paid annual leave. You'll see this at the beginning of paragraph 22. In order to give a helpful answer to the National Court, it's appropriate to step back and, above all, place the entitlement to paid annual leave in the wider context of fundamental social rights. The right at issue was not upheld for the first time in the Working Time Directive. It has long been included together with an indication of the period of leave guaranteed amongst fundamental social rights. And there is then a very similar analysis in BECTU to the one I've already taken you to in Stringer, that is looking at some of the international law provisions. At paragraph 29, the Advocate General considers the scope of the right to paid leave and you'll see at the end of paragraph 29, the last sentence, as a fundamental social right, the right to paid leave is characterised also in the directive as, to use the Commission's word, an automatic and unconditional right granted to every worker. And then from paragraph 32, there's reference to the possible limitations of the right to leave. And the Advocate General's view at paragraph 33 that the UK government has interpreted the scope of the expression, and that's referring back to in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation and or practice too widely. And then paragraph 34, it's not of course my intention to deny that the expression in question means that reference must be made to national legislation and that therefore the member state enjoys some latitude in defining the arrangements for enjoyment of the right to leave. In particular, as the Commission also points out, the reference is intended to allow the member states to provide a legislative framework governing the organisational and procedural aspects of the taking of leave, such as planning holiday periods, possibility that a worker may have to give advance notice to the employer of the period in which he intends to take leave, the requirement of a minimum period of employment before leave can be taken, the criteria for proportional calculation of annual leave entitlement where the employment relationship is of less than a year, and so forth. But these are precisely measures intended to determine the conditions for entitlement to and granting of leave, and as such are allowed by the directive. What, on the other hand, does not seem to be allowed by the directive is for national legislation and or practice to operate with absolutely or almost no restrictions and to go so far as to prevent that right from even arising in certain cases. And that is picked up.
The criteria for proportional calculation of annual leave entitlement,
yes,
where the employment is less than 1 year, does that mean that if there was employment of, say, half a year, you could say, we're not actually giving you half, we give you 2/3? I mean, what else does it mean?
Well, it's allowing
we
for...
give you 1/3,
yes,
rather.
It is allowing for proportional calculation. In fact, there's an example of that, I think, in 13A of the Working Time Regulations. But you can give, yes, that the member state can provide for proportional, but what it must do...
It doesn't have to be absolutely pro rata, of course, does it? I mean, or does it?
Well, it would have to guarantee the threshold, that is the threshold of paid annual leave providing for normal remuneration. So if...
The question is what latitude is.
Yes.
I'm interested in that one because it suggests there may be some substantive latitude.
Well, a typical example would be whether you had to do it day by day or whether you're doing it by the number of weeks of employment during the year is a possibility, isn't it?
Yes, and it's done in relation to payments in lieu of leave, specifically within the regulations, that there is a proportional calculation. If, for example, your employment is terminated 6 months through the leave year and you haven't taken any holiday, then there is a prorating of your payment in lieu, and that's perfectly legitimate. That is within the conditions that a member state can lay down, because it's about the implementation and it doesn't affect the substance of the right. So 15A. the regulation. Just picking up in the judgment and demonstrating that the Advocate General's opinion in this respect has been accepted and adopted by the court in this case. 1173, paragraph 53. It's 1173 at B. The expression in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation or practice must therefore be construed as referring only to the arrangements for paid annual leave adopted in the various member states. As the Advocate General observed in paragraph 34 of his opinion, although they're free to lay down in their domestic legislation conditions for the exercise and implementation of the right to paid annual leave, by prescribing the specific circumstances in which workers may exercise that right, which is theirs in respect of all the periods of work completed, member states are not entitled to make the existence of that right, which derives directly from Directive 93104, subject to any preconditions whatsoever.
You referred a moment ago to something in the regulations which dealt with proportional calculations. Can you just give me the reference?
Yes, it's in relation to the working time regulations,
yes.
Tab 5.
Yes.
That if you go to Regulation 4, which deals with compensation payment in lieu of leave, 14.2, you'll see there's a specific formula that's set out at 3.
Oh, yes. Sorry, Regulation 4.
It's Regulation 14.
14.
I'm sorry, that was my mistake. 14.2.
Yes.
You'll see a formula there set out. And similarly at 15A, leave during the first year of employment. Which also refers to a proportion, that is a proportion during the first year of employment. So those are examples of where proportions may be provided for.
So you can have an agreement about that, can you?
Well, the regulations provide for the formula. That's the way that the UK has implemented its European
No, you can have an
obligations
agreement.
on working
The calculation,
time.
the formula is where there's no agreement.
Yes, there may be a relevant agreement, and that's a relevant agreement as defined in the regulations. So it may be a collective agreement, for example. And that's an agreement specifically to undertake additional work or to compensate his employer by a payment. It doesn't eat into the right to 4 weeks paid leave. (15A) doesn't provide for any relevant agreement. Well, just before leaving Beck 2, can I just pick up on one other point that was considered important by the Court of Appeal, which was the question of direct effect. As I made clear at the start, claimants have never relied on direct effect in this case, always accepting that BA is not an emanation of the state. And I pick this up only because it was considered important by the Court of Appeal at paragraphs 57 and 58 of their judgment, if I could just go to that in relation to the nature of the right to paid annual leave. It's at pages 25 and 26 of the appendix. And starting at paragraph 57, there's reference at paragraph 56 to the fact that direct effect had not been in dispute between the parties. It's perhaps given a broader, certainly a broader reference than was intended by the claimants. It's not being said by the claimants that there could never be direct effect. It was saying that there was no direct effect in this case, and there was no argument in relation to this issue. Paragraph 57 refers to Article 7, and the conclusion at the end of that paragraph, I don't accept the Court of Justice decisions relevantly inform the interpretation of Regulation 4 in a way sufficient for the pilot's purposes. And then the problem with Ms McNeill's contrary argument is this. First, neither Article 7.1 nor Clause 3 is directly effective. Now, to the extent that it may be relevant, Beck 2, we submit, establishes that Article 7 of the Working Time Directive is capable of having direct effect. That submission was not made below, where direct effect wasn't argued in any detail at all.
But which bit of Beck 2 establishes that?
Well, the bit of Beck 2 that refers to it being unconditional, can I just go back? I think it's 34, the Advocate General, and then it's the provision that I've referred you to. 34 of the Court.
It's 53 of the Court, isn't it, that you took us to?
Yes, I took you to 53, but 34 of the Court, at page 1170, just below letter H.
This was a claim against the British government, Beck 2?
Yes.
So, I mean, direct effect is completely irrelevant. The claim was that the British government had enacted regulations which were contrary to its international obligation under the directive.
Yes.
So it has nothing to do with direct effect.
Yeah, but the Court looked at whether Article 7.1 did impose a clear and precise obligation and found at paragraph 34 that Article 7.1 imposes a clear and precise obligation on member states to achieve a specific result, by virtue of which they're to take the measures necessary to ensure that every worker is entitled to paid annual leave of at least 4 weeks. So clearly the court in Bectu did think that Article 7.1 imposed a clear and precise obligation on member states, and that view has also been taken by Mr. Justice Elias, as he then was, in a case before the Employment Appeal Tribunal.
That's simply a precondition. The content of the international obligation has to be sufficiently certain for the UK government to be said to be in breach of something, but that has nothing to do with whether the international obligation has direct effect. They're two different questions.
Yes, they are two different questions.
Yes.
And similarly, in the current case, direct effect simply doesn't arise, and perhaps I'm simply flagging it up because the Court of Appeal seemed to think it was important.
But I take that point, that it's difficult to know what the Court of Appeal is getting at precisely.
Well, if British Airways was still an emanation of the state, as it used to be,
Yes.
would you be arguing that it was direct
Yes.
effect?
And we'd be arguing that on the basis of the provisions of the directive and on the basis of Bectu, where we say the European Court, albeit that it wasn't part of its ratio, did consider that these were sufficiently precise obligations. The only...
Well, again, I repeat, that has nothing to do with the question whether they have direct effect. It's a precondition to holding a state liable under community law that the content of the obligation is clear.
Yes.
But obviously, and there's quite an interesting discussion about the whole context, the whole effect of directives in a case which I think is of some general importance, called SEDA and Swedex,
yes.
On the 19th of January 2010 in the European Court. That's SEDA and Swedex. And it's the Advocate General's opinion certainly draws the distinction that I've been making,
yes.
And I think the Court does too.
Well, Lord, I don't in any way seek to go behind that. Perhaps I can deal with it in this way. If direct effect is considered a point of importance, and if it's raised by the respondent, I will deal with it in reply.
No, I mean, your basic point is the much simpler point that there is a clear international obligation, and it is our duty to construe the regulations as far as possible consistently.
Yes.
If it is impossible to construe them consistently with the clear international obligation, then we can't do it, and the UK is in breach. That's the European law.
Yes.
But I'm not quite clear why Bectu carries you very far. I mean, all it says is you can't have any precondition to the right to a paid annual leave. It doesn't tell you what paid annual leave means.
No, it wasn't an issue.
Exactly. So why does Bectu help?
Because Bectu makes it clear what the scope of in accordance with national legislation and or practice means, and makes it absolutely clear that the words in accordance with national legislation and or practice do not enable the member state in any way to interfere with the community law concept, the right. All those words mean. That's the reason we refer to it.
But it does beg, I mean, as my Lord's pointing out, it does leave open the question of what is meant by paid in community law.
And that brings me to my next case, if I may.
Does it mean anything particular?
Yes.
And I think the Court of Appeal's argument is that it doesn't, because by itself it can't mean anything. It needs to be, it must be spelled out at national level, they're saying, effectively.
Well,
therefore, it must be a national matter, because it's not something which can be spelled out sensibly at a European level, and therefore it can't be something which is embraced within the word paid. That, as I understand, is the underlying sense of what they're saying.
yes. But, my Lord, we say it can be spelt out. It has been spelt out by the European Court of Justice, and the domestic regulations have to be construed in compliance with that. And we say that the somewhat qualified meaning that the Court of Appeal gave to it, that is that it was just some general principle, that is normality was some general principle, is simply not correct, that the European Court of Justice has very clearly set out what paid annual leave means. Lord, having said that, can I go to the case of Robinson Steele, which is at tab 42 of volume 3?
Tab what?
Tab 42.
42, thank you.
Authorities, volume 3. And I'll refer to the case, if I may, as Robinson Steele. In fact, there were 3 cases. 2, Clark and Frank Stadden and Caulfield and Hanson Clay were both referred by the Court of Appeal, and Robinson Steele itself was referred by the Leeds Employment Tribunal, but they raised common points on the lawfulness of what's become known as rolled-up holiday pay. That is, holiday pay which is rolled up together with a worker's ordinary weekly or monthly pay by agreement, and in the case of Marshall's Clay, indeed, by collective agreement with recognised union. And Lord Justice Laws, with whom the other members of the court agreed, considered that rolled-up holiday pay was lawful. The European Court of Justice disagreed with that. And if I could just go to the head note of Robinson Steele.
Do we have the Court of Appeal judgment too?
Yes, you do. It's at tab 20, and I can take you to the relevant part if it would assist.
Well, I'm not asking you to do that. I just wanted to look. Thank you.
Yes, it's at tab 20, and just for your note, page 1519, you'll find what Lord Justice Laws concluded.
So can you just in a simple sentence tell us what rolled up holiday pay means?
Rolled up holiday pay means when you get the same payment week by week or month by month, but includes an element of holiday pay. That is, the employer says, within this payment of £200 a week, £25 is attributable to holiday pay. So it's a rolled up sum. And then you don't get paid anything extra.
Then you don't get paid during the holiday.
No, so you don't get paid anything else during the holiday. You just get the rolled up sum.
So you work for a year, you get 4 weeks paid nothing, but the other 11, the other 11 months you get the supposed pay for the holiday.
The rolled up payment, the payment which is stated to include your holiday pay. Yes, and it has been fairly common, or was until these cases. There were a number of cases before the tribunals in relation to this sort of system.
I can't remember what's the point of it. I mean, why do you get paid that way?
Well, because it's a lot easier in certain, particularly where there are shift payments, for example.
Wouldn't it also be easier in the olden days when people were paid a weekly wage in a wage packet,
yes,
in cash, so you handed it over, and when they weren't there because they were on holiday, they weren't there to pick up their pay, so you did it by adding a bit to each weekly wage packet in order that they got it. Isn't that what it comes from?
Yes, that's where it comes from, but also there were cases where there were complications related to shift pay, and it was agreed, and in some cases agreed with unions, as it was in the Marshall's Clay case. The Marshall's Clay case agreed with the union that this was an adequate method, but the European Court of Justice says no. Lord, I don't know if that short circuits my reading
however it was calculated.
Yes. However it's calculated.
So even if it was calculated on the express basis that your normal pay for the period you were working was X, and that you'd be paid the 4 weeks, and you'd be paid your normal pay, giving it your meaning, you couldn't still pay it on a rolled-up basis.
That's right. That's right. There was.
Why is that? I mean, that seems to be absurdly.
It's a decision by reference to the frailties of man or womankind, isn't it? If you get money now, it might get spent, and you might never take any holiday.
It's the idea is
Maybe
you're paid when you go.
Really.
when you go on holiday, it's all part of encouraging people to take to take holidays, and yes, that is the position. And the only very slight caveat to that was that there were certain circumstances in which, if it was transparent, there could be a set-off in any claim against for sums of money received. But I don't think, for the purposes of this case, we need to go into that. So if I could, perhaps having given that explanation, just read out what was held. It was held that Article 7.1 of the Working Time Directive precluded part of the remuneration payable to a worker for work done from being attributed to payment for annual leave without the worker receiving in that respect a payment additional to that for work done. It was not permissible for a worker's entitlement in that respect to be derogated from by contractual arrangement. Article 7 precluded the payment for minimum annual leave within the meaning of that provision from being made in the form of part payments staggered over the corresponding annual period of work and paid together with a remuneration for work done, rather than in the form of a payment in respect of a specific period during which the worker actually took leave. And that while Member States were required to ensure that practices incompatible with Article 7 were not continued, that article did not generally preclude sums for annual leave that, contrary to the directive, had already been paid in the form of staggered part payments from being set off against payment for specific leave, provided the sums had been paid transparently and comprehensibly, the burden of proving which was on the employers. In Robinson Steele, the nature of the right to paid annual leave is very clearly set out by the European Court of Justice at paragraphs 48 to 50, which are found on page 958, just below letter D. And this is when considering the second question in the case, which was whether Article 7 precluded part of the remuneration payable to a worker for work done from being attributed to a payment for annual leave without the worker receiving in that respect a payment additional to that for work done. And the European Court of Justice says this: in that regard, it must be recalled that the entitlement of every worker to paid annual leave must be regarded as a particularly important principle of community social law from which there can be no derogations, and whose implementation by the competent national authorities must be confined within the limits expressly laid down by the directive itself, and there's reference to paragraph 43 in Beck 2. The holiday pay required by Article 7.1 of the directive is intended to enable the worker actually to take the leave to which he's entitled. The term paid annual leave in that provision means that for the duration of annual leave within the meaning of the directive, remuneration must be maintained. In other words, workers must receive their normal remuneration for that period of rest. And then there is further clarification of the nature of the right over the page at paragraphs 58 to 59, and this is where the question of the timing of the payment is being considered. And it was argued in that case, and I take this from paragraph 55 at C, under Article 7.1, Member States to take the measures necessary to ensure that every worker is entitled to paid annual leave at least 4 weeks. And then there's the reference to the phrase in accordance with. The fixing of the point at which the payment for annual leave must be made comes within those conditions. In that regard, the Member States must ensure that the detailed national implementing rules take account of the limits flowing from the directive itself. The directive treats entitlement to annual leave and to a payment on that account as being two aspects of a single right. The purpose of the requirement of payment for that leave is to put the worker during such leave in a position which is, as regards remuneration, comparable to periods of work. And then at paragraph 62 at the bottom of the page, again says that Article 7 is not one of the provisions from which the directive expressly allows derogations. Therefore, it does not matter whether such a regime of paid annual leave is or is not based on contractual arrangement. And we take from that this is a composite right. The right to paid annual leave is a composite right. It's a right to annual leave, and it's a right to payment for that leave. And the right to payment is a right to normal pay. That is the maintenance of normal pay. That's one part of the decision. The purpose of the payment which is the second part of paragraph 58, the purpose of the payment is that the worker should be in a position as regards remuneration which is comparable to periods of work. So that's the purpose behind it. And paragraph...
how does it work? I mean, assume that you're booked for a month, I don't know, to go to Benidorm, whatever. And everybody agrees that you're entitled to £500 for that month, whatever it is. I mean, what's the employer got to do? Send it you, obviously not day by day, week by week, pay you in advance, pay you in... How does it work?
Well, mechanisms may vary from employer to employer, and there's nothing in the provisions on national legislation and or practice that stop different employers having different schemes. But the important thing is that what you should be receiving is your normal remuneration, that is maintaining the normal provision. So you'd be paid at the normal date. If you were paid monthly, you'd be paid at the end of the month. If you were paid weekly, you'd be paid week by week. It's maintaining the status quo while you're on holiday.
They're not allowed to pay you in advance. I mean, so you might want to book a hotel, and they might want whatever it is. They might want money up front. Can't you say to your employer, can I please have £250 a couple of months earlier? I've got to pay a deposit or something.
Of course, you could ask for that. You could enter into an arrangement with your employer. If it was several months previously, the employer might possibly be placing themselves at risk in the light of the Robinson Steele judgment.
I mean, what is rolled up pay, but in a sense, paying in advance?
Well, Lord, that's right. The European Court has clearly said rolled up pay is not permissible, and the reason it's not permissible is that you have to be paid your normal remuneration. It couldn't be clearer in my respectful submission what the court is saying. That is, that you have to be paid your normal remuneration when you're on annual leave.
Where does the normal come in?
The normal comes from paragraph 50. Term paid annual leave means that remuneration must be maintained.
But they were dealing with a very extreme situation, as you look at see in paragraph 51. They were dealing with the situation where the man is being paid, say, £100 a week for the work, and then they suddenly realise they ought to give him holiday pay, so they say, you're going to be paid now £100 a week, but 10% of it is for holiday.
Yes, plainly wrong.
And he still gets nothing during the holiday period under either arrangement. So that was... And similarly, over the page, they're also dealing with the situation where actually the staggering of the pay over the year means that you've got nothing at all during the holiday period.
Yes.
So, I mean, they are extreme situations, but you rely on the words normal and comparable.
Yes.
Yeah.
The facts of Robinson Steele plainly are different to the facts of the current cases, but what is clear is that they're not just setting out something that applies to the facts of those cases, but they are setting out principles. They're setting out the meaning of paid annual leave. I mean, they say so in terms at paragraph 50. This is what paid annual leave means.
What about paragraph 60? I mean, I think that's relied on against you. They say that the rationale, the prohibition is intended to ensure that a worker is normally entitled to actual rest with a view to ensuring effective protection of his health and safety.
Yes.
Now, I think nobody is suggesting that the level at which airline pilots, etc., are paid, excluding their away from home supplements, is damaging to their health and safety.
Well, Lord, each case is different on its facts, and it's not been suggested that British airline pilots don't take their holidays because they can't afford to, but it's more fundamental than that. British airline pilots have to take their holidays because they're contractually obliged to take their holidays.
Have a rest,
but no, this is not a case where that is being relied on. But that would be, with greatest respect, an impossible test. And indeed, the Employment Tribunal say so, paragraph 70 of their judgment. You could not look at each worker and say, is this individual deterred from taking their holiday because they're only being paid basic pay? It just is an impossible test.
I mean, in any of these
Virtually
cases, I'm so sorry, I'm sorry, Sharon. In any of these cases, I mean, was there any question of a sort of imbalance month by month as to pay, or is it just absolutely a routine, so much a week or a month throughout the entire period?
I think it's in the nature of rolled up holiday pay that it's routine. That's why employers use it. It's a simple.
No, quite, but therefore it's not our case where there are sort of additional elements. I mean, I don't know. I mean, there must be quite a lot of it. I mean, footballers presumably get paid more when they play a match or whatever it is. I mean, what is a normal pay in the, to use the expression in paragraph 50 to which you refer us?
Well, normal pay is maintaining your level of pay, and of course there are situations. I perhaps answered my previous question too shortly. Of course, there are cases where shift workers, for example, may get different levels of pay from week to week or from month to month. There are numerous areas of employment, as we all know, where workers don't get a regular payment each week, but the courts and employment tribunals have to deal with this all the time.
But
and indeed, I'm so sorry.
I'm sorry, I interrupted you. I was just going to comment. I mean, no doubt one can imagine all sorts of exotic examples, but so far as your clients are concerned, so far as your principal named client is concerned, page 257, which you've shown us, strongly suggests, as one would expect, that her salary and allowances are paid monthly into her bank account, and that it would arrive into her bank account whether she was at Ulster or on holiday at Benidorm. I mean, that's the position, isn't it?
Yes, and month after month after month, the pay includes flying pay supplement and time away from baseline. She's a pilot.
Except when she's on holiday.
Except when she's on holiday, but you can't define holiday pay on the basis that you're not working, because the whole point of holiday pay is to get your normal remuneration.
And you couldn't say, well, when you're on holiday, you're just resting, so it's for any reason we should pay you much less for that than you were when you were sitting in the cockpit.
I think in this day and age that the employer wouldn't get very far with that. Of course, there was a similar point in the Stringer case, which I'll come to in a moment, where the employees were off on sick leave and therefore receiving either half pay or no pay, but was still entitled to 4 weeks annual leave with full pay, and I will go to that in a moment.
But are we going to get any cases where there are people earning these widely different amounts because of overtime or whatever, or because they're footballers who must be paid a lot more at one part of the year than another? Are there any cases which, so to speak, demonstrate how you calculate the, or do you say they're all under whatever it is, sections 2.5 or 2.4, whatever it is, and that tells you how to do it?
Under the working time regulations, I would like to say you're told how to do it, but there is, of course, the reference to the formula in sections 221 to 224.
Right.
It can cause exactly the same problems as could potentially arise in this case if there are irregular earnings. There are averaging out procedures. There have been arguments about whether you should take into account bonuses or overtime. The formula under sections 221 to 224 is not something that an employer can just look at and say, oh, well, that's easy, this is how I do it. But there's no difficulty in arriving at normal remuneration. You carry out an appropriate averaging process, and you arrive at a figure which is just and equitable, which is what the Civil Aviation Working Time Regulations say.
As a matter of interest, it's not frightfully easy to see in which months your client must have been taking her holiday.
No, it's
or
not.
Periods of her holiday.
No, it's not obvious on the face of it. I think there are some numbers put into the schedule, which I think may indicate at the side in brackets that days when she was.
Oh, I see a number of days.
She had a number of number of days holiday in those particular months.
I believe that's what those numbers refer to, but this is a schedule produced by.
It's actually.
Yeah, I see Mr. Short nodding his head, but I don't know if he's nodding.
What is very interesting then, on that basis, is that if you look at February, despite the fact she was on holiday,
I don't know.
she in fact
What page are you on?
257. Despite the fact she was on holiday, she in fact received more by way of flying pay than in the previous month or in the next month.
Well, that may very, I mean, that can be the case because it may be in a particular month that the duties that an individual is undertaking involve more duties which incur flying pay supplement. But
presumably, I mean, supposing she I don't know how the limits on flying pay are calculated, but supposing she'd exhausted in February her flying hours, on your argument, she's still entitled to more payment by way of flying hours because it's part of the average.
yes, because it's part of the average. She's got to be treated as though she's working normally, so it's maintaining her.
But she couldn't have been, is the
No,
argument.
she's on holiday.
Yes.
Yes, but because you're on holiday, that can't be a reason for not paying you your normal pay. In fact, that would stand the test in my submission on its head. But you must be paid your normal remuneration.
Actually, that's a very important way in which you've just put it.
Yes.
You've got to be treated as if you were working,
Yes.
normally.
You wouldn't be paid anything otherwise.
Yes, exactly. Exactly.
And how does it work for footballers, say, who earn £170,000 one week? Well, probably every week.
Or bankers' bonus.
During the season. Or bankers' bonuses.
Yes, what happens after the 31st of January?
Well, if they're within the working time regulations, they may have to go to the provisions of sections 221 to 224, but... Can I then turn, moving on...
Well, I suppose you'd say, well, these would all be matters of fact for the Employment Tribunal to work out.
Yes, I mean, what would happen in practice? Once the principle's established within the civil aviation sector, is the likelihood is that appropriate calculations will be agreed, provided they don't breach the principle of normal remuneration. That's what's likely to happen in practice, I suggest. If not, then the
Perhaps you'll have to
Employment
agree to lower normal remuneration in order to avoid bankruptcy of the various airlines.
I think in view of paragraph 62 of Robinson Steele, you can't agree a lower level of remuneration because, of course, the contract...
Even if it's going to make you bankrupt?
Can't define the nature of the right.
Even if it's going to make you bankrupt? You can't make an agreement with your... Is that really right?
I thought
My lord is suggesting that the ordinary pay would have to go down. The normal pay would have to go down.
Oh, I'm sorry.
That's
yes.
what he's
That was
suggesting.
I'm so sorry. I
That's what I intended
misunderstood
to
the question.
suggest.
I'm so sorry.
Because
Yes.
the airlines wouldn't be able to afford it if you won, the pilots would have to put up with a much lower rate of basic pay eventually.
And if they agreed to that, then there would be nothing wrong on your analysis with... as long as they agree, as long as they make they can make whatever agreement they like about ordinary pay.
Yes,
It's only holiday pay they can't make an agreement
absolutely. Absolutely. And I'm
about. So
sorry.
as
I
long as they do
misunderstood the
agree to ordinary pay,
Yes.
then they're all right.
I think they've already agreed to a reduction in their pay, haven't they?
Yes, it's been
recently,
I think,
yeah.
pretty well publicised that the unions and BA have been in negotiations on very many matters recently.
Yeah.
And
Well, have we finished with Robinson
we've
Steele?
finished with Robinson Steele. Can I go on to Stringer? Stringer is at tab 43 of Authorities Bundle 3. And this is a case which went to the European Court of Justice and then came back to Your Lordship's House. This is the judgment of the European Court of Justice. There were two cases heard together. The UK case, Stringer and others against Revenue and Customs Commissioners, and then a German case, Schulzhoff. And they both raised similar points. And in essence, they involved the right to paid annual leave when off sick, and also the right to a payment in lieu of annual leave following termination of employment after a period of sickness. And in the Stringer cases, they were referred to the European Court of Justice by the House of Lords on the basis that the interpretation of Article 7 of the Consolidated Working Time Directive was open to dispute. Just referring to the head note, I'm happy to read that out. Would your Lordships prefer just to read it to yourselves rather than my reading out the whole of the head note? I'm very grateful. And may I just highlight at the end of paragraph 3, subparagraph 3, you'll see the last clause: in calculating the allowance in lieu due to such a worker, the worker's normal remuneration, which was that which had to be maintained during the rest period corresponding to the paid annual leave, was decisive. So there was an issue of calculation in the case. The references concerned whether a worker could take annual leave whilst on sick leave, but also whether the entitlement to annual leave could be extinguished after the period allowed by national law for the taking of annual leave, but also concerned the right to pay in lieu of leave not taken and the calculation of the allowance in lieu of annual leave. That was the second question in Stringer, which overlapped with the second question in Schultzhoff. And that's of particular relevance to the current cases because it concerns not just the entitlement to an allowance in lieu of sick leave, but also the amount of an allowance in lieu of annual leave, which the court held should be calculated in exactly the same manner as pay during annual leave. So the Robinson-Steele analysis is also applied in circumstances where there is a payment in lieu of leave.
Can you just help me? I mean, I ought to be able to remember, but I can't. I mean, at least one of these cases was somebody on very long-term sick leave, is that right?
Yes.
And were they getting sick leave? You get paid, what, half your basic salary or something?
Well, it's often 6 months and then 6 months. 6 months full, 6 months half,
okay.
Yes.
Now, for those people, when they were held entitled, notwithstanding they were permanently on sick leave, but they were still entitled to their annual holiday.
Yes.
Now, what rate of pay for that? Was that
at the normal rate of pay, full pay?
So full pay?
Yes.
So even though actually they've been on less than full pay because of sick pay, they still get full pay?
Even if you're on no pay?
Even if you're on no pay for a year's sick leave,
yes,
you're entitled within that year to have 1 month full pay.
Well, it goes further than that. You could be off sick for a full year. Your employment is terminated at the end of 12 months. By that time, you may be receiving no pay at all. And if your employment is terminated, you are still allowed a month's pay in lieu of leave, or 4 weeks' pay in lieu of leave, calculated on the basis of full pay. And indeed, even if you're still in employment and you say, right, I'm now better, I want to take 4 weeks' holiday, subject to conditions of notice and so on, but full pay. That was, and I think all of them had been off sick for a whole year in the Stringer case.
Yeah.
What happens if you take a month's holiday in order to go on a wonderful cruise, and on the first day of the cruise you suffer terrible food poisoning and you're ill for 3.5 weeks? Can you demand 3.5 weeks holiday during your next period of employment?
Well, I think the answer is that you may now be able to. In fact, I think you are now able to. If you're sick, if you're not taking holiday, but you're effectively then taking sick leave because you've become sick whilst on holiday, you are still entitled to annual leave.
It's a Spanish case called Parade.
Yes. Thank you. I'm reminded by Mr. Ford. It's a Spanish case called Parade. It has been decided this particular point.
Sorry, that has been decided.
Yes.
Just shows you can't apply common sense in these cases, isn't it?
If you're sick on your holiday, you get a longer holiday.
Yes, because you're then sick. If you're then effectively on sick leave, you're not taking your annual leave. Your annual leave is for you to have a
to enjoy yourself.
Yes.
You can't possibly enjoy yourself if you've stuffed yourself a party full of seafood.
Our life is work, and anything else is catered for.
Do you want to show us any particular bits in Stringer?
Yes, I do want to go to various bits in Stringer, but just before I do, can I... no, I'll go straight to Stringer. In relation, it's really the second question in Stringer, which I'm going to be focusing on most of all, and it's summarised at page 982H, paragraph 53. And that's where the Advocate General, where the court sets out
I'm so sorry,
second...
page what?
Sorry, 982.
The 982, sorry.
At letter H, there is a summary of the second question in Stringer. The right to an allowance in lieu on termination of employment relationship in respect of paid annual leave not taken in the leave year and or in a carryover period. That really refers to the German case, the carryover period, on account of incapacity for work for the whole or part of the leave year and or of the carryover period. And the ECJ in Stringer was faced with arguments by member states that they, that is the member states, had a discretion to determine how the allowance in lieu under Article 7.2 was calculated. And the member states argued, or a number of member states argued, that matters of financial compensation relating to periods of annual leave did not fall within the scope of the Working Time Directive, but were a matter for national legislation and or practice. And you find that in the Advocate General's opinion, pages 941G to 942H. And I'm going to refer in particular to the arguments of the Belgian government, the Czech government and the Slovene government. Paragraph 34, I can really take it to, at the end of the paragraph. The Belgian government proposes that the second question be answered in the negative, to the effect that the conditions and detailed provisions relating to financial compensation do not fall within the scope of the directive and are instead a matter for national legislation and practice. And then the Czech government similarly, and again I go right to the end of the paragraphs, paragraph 35. Even though it doesn't preclude a corresponding national rule, the directive lays down no requirements relating to a possible entitlement to an allowance in lieu in respect of leave which was not taken due to illness. And then the Slovene government, last sentence, where a member state does provide for such an allowance, that is the allowance in lieu, the calculation thereof is subject solely to national law. And the Advocate General rejected that analysis at paragraph 90. That's where you find her conclusions. Page 958H, as regards the broader question concerning calculation, 958H, as regards the broader question concerning calculation of the compensation due, the answer must be that Article 7.2 of the directive does not lay down any particular method of calculation and instead leaves the adoption of precise rules to the national legislature. However, insofar as all workers are in principle entitled to an allowance in lieu, in the assessment of the amount of that entitlement, account must be taken of the fact the worker had originally acquired an entitlement in the amount of his normal pay. That gives rise to the requirement on the member states under Article 7.2 to ensure that the amount of the allowance in lieu that the worker receives is equivalent to that of his normal pay. And again, the European Court of Justice follow the Advocate General's opinion. You find this at 983B. To 984A. It's paragraphs 54 through to 61. Referring first of all at 54 to Article 7 and the fact that there can be no derogation. Every worker is entitled to paid annual leave of at least 4 weeks. Right to paid annual leave, which according to the case law must be regarded as a particularly important principle, is therefore granted to every worker, whatever his state of health. And then 55, the right to paid annual leave is not extinguished at the end of the leave year and or carryover period, laid down by national law, where the worker was on sick leave for the whole or part of the leave year, hasn't actually had the opportunity to exercise the right. On termination of the employment relationship, it's no longer possible to take annual leave. In order to avoid that, as a result, the right in question, in order to avoid that, as a result, the right in question cannot be enjoyed by the worker, even in pecuniary form, Article 7.2 of Directive 2003 provides the worker is entitled to an allowance in lieu. And then the court says that no provision in the directive expressly lays down the way in which the allowance in lieu of the minimum period or periods of paid annual leave must be calculated where the employment relationship is terminated. However, referring to Robinson Steele, according to the case law of the court, the expression paid annual leave in Article 7.1 means that for the duration of annual leave, remuneration must be maintained. In other words, workers must receive their normal remuneration for the period of rest. And then it's applied at 59 to the allowance in lieu. When determining the allowance in lieu payable under Article 7.2, the member states must ensure that the conditions for application laid down by national law takes account of the limits which derive from the directive itself. According to the case law of the court, the directive treats entitlement to annual leave and to payment on that account as being two aspects of a single right, and then there's repetition of what's set out in Robinson Steele. Paragraph 61, it follows that with regard to a worker who's not been able, for reasons beyond his control, to exercise the right to paid annual leave before termination of the employment relationship, the allowance in lieu to which he's entitled must be calculated so that the worker is put in a position comparable to that he would have been in had he exercised that right during his employment relationship. It follows that the worker's normal remuneration, which is that which must be maintained during the rest period corresponding to the paid annual leave, is also decisive as regards the calculation of the allowance in lieu of annual leave not taken by the end of the employment relationship. And the question then is answered at paragraph 62. So the same principles applying. Very last sentence of paragraph 62, for the calculation of the allowance in lieu, the worker's normal remuneration, which is that which must be maintained during the rest period corresponding to the paid annual leave, is also decisive. Laws, I was proposing, and I'll be fairly short, just to deal with the first question in Stringer, but this may be a convenient moment.
I think probably this would be a convenient moment. We will look forward to hearing some more at 2 o'clock.